After completing with all the topics that we've done, let's just try to summarize what we've done till now. Till now, we have understood what is a contract and how does a contract become enforceable by law. What are the essential requirements of a contract? So let's start with a contract. What is a contract? Contract is an agreement enforceable by law, we said. Then we understood what is an agreement. Agreement, we said, is a set of promises forming consideration for each other. And then promise was defined as acceptance of a proposal. When a proposal is accepted, it becomes a promise. And then we defined acceptance as when the person to whom the offer is made signifies his assent thereto, he is said to have accepted the proposal. And then we understood what is offer or proposal. We said when a person expresses or signifies his willingness to do or to abstain from doing anything with an intention to obtain the assent of that other, he is said to have made a proposal. So for a contract we require 5 things. First was proposal, it's the most basic things, and for that proposal we require acceptance. And when a proposal is accepted, it becomes a promise. The set of promises forming consideration for each other make an agreement. So we have 4 things here. And finally, when this agreement gets the enforceability of law, we have a contract. Then we saw how does a contract get enforceability. That is, what are the essential requirements that makes an agreement enforceable by law and thereby a contract. First was intention to create a legal relationship. We said when the two parties are transacting, the parties need to intend to bind each other legally. They need to create a legal relationship with each other. If this is not present, there is no contract between the two. Then we said the object of the contract, that is the purpose of the contract, should be lawful. It should not be against law. At the same time, the consideration which is being given, it should also be lawful. Then we said the parties who are entering into the contract should be capable. They should have the capacity to enter into agreements. We said minors do not have the capacity, people of unsound mind do not have the capacity, and some disqualified persons do not have the capacity. Then we did free consent. We said consent should be free for making a valid contract. However, when coercion, undue influence, fraud, misrepresentation, and mistake are present, the consent is not said to be free. And when the consent is not free, the contract becomes voidable. Only in case of mistake, the contract becomes void. Then we did agreement not expressly declared as void or illegal. Then we did various agreements which were listed under it. All such agreements which are listed or which are expressed as void by law itself will always be void, because law itself is saying expressing them as void, so they become void only. So it is a requisite that an agreement should not be one of those. It should not be void to become valid. Then we saw the certainty in meaning. We said a contract should be very crisp and clear. It should be definite and specific. There should not be multiple meanings. It should not be ambiguous. A contract should not be loosely meant or it should not be vague, but it should be specific, to the point, and properly defined. All terms should be mentioned. So contracts which are not certain will become void. Contracts which are certain will become valid. Then we did possibility of performance. It should be possible to perform the contracts. All contracts which are impossible in nature, which cannot be performed by humans, will become void. They can never be enforced in law. However, contracts which are normally possible, normal business contracts, will be valid. They should not be impossible to be valid. And finally, we learned necessary legal formalities. We said necessary legal formalities is not an essential requirement for all the contracts. It is required only for some specific contracts like sale of property, gift deeds, etc. So this completes the third, your topics till the third unit. The first unit being the nature of contract, second unit being on consideration, and third on the essential elements. See you again in the fourth unit on the performance of contracts.